Welcome back everyone, and for this video I'm going to be looking at the topic, quite a big one in fact, Occupiers Liability Act, which consists of the 1957 Act and the 1984. And again, if you're doing tort law paper 2 for the AQA exam board, this is a significant topic, quite detailed because it covers both, it's statutory, but it does also have common law there in terms of cases that further elaborate on the points. So it's a combination of knowing the two, really. So following what we've done before, I've tried to condense everything down into preferably one sort of slide or one handout, which you're welcome to download from the description below and print off your folder. So if we just run through, I might touch on some of the facts of the cases, but ultimately, if you're struggling to remember the facts, it's really just trying to match the legal authority, the section number, or indeed the case, to the point that you're making. So the 1957 Act, first of all, references only lawful visitors. So in this instance, we're talking about the claimant who has suffered a personal injury or indeed, property damage. Generally, I suppose exam questions on this basis is where somebody is on another person's property, but as we'll see with premises in a moment, it doesn't necessarily just always have to be, a house. I've seen exam questions also have, it's a shop, an alleyway between a shop. It can also be anything within a building, for example, on the land itself, part of that. So we'll look at that in more detail in a minute. But generally, lawful, you're immediately needing to identify that in the problem scenario as being relevant to claims under the 1957 Act, and that's, for instance, anyone that's invited, for example, to the property or land, anyone who is licensed to be there. Again, just very quickly, it could be postman, for example. Contractual or statutory, again, I suppose police officer has a statutory duty in terms of sort of fulfilling their job if they need to come onto your property in certain circumstances. Contractual would be if you hire someone like a tradesperson, like a plumber or something, to come onto your property. So identify, that it is a lawful person, and then try and explain why they are lawful. The second point is to identify an occupier. So of course we've in point one dealt with our claimant, but if there is no occupier, and in this instance whoever is in control of the premises is considered to be the occupier, according to the case of Harris and Birkenhead. So there can be more than one occupier, but whoever is in control would be sufficient. It could be, for example, not simply a person who owns the land or the property. It could equally be somebody who has a lease or who rents it, or indeed it could be, maybe the occupier or of the property has gone out and left someone else responsible. Maybe it's another family member or friend, and that's when the personal injury occurs with the lawful visitor. So generally it's whoever's in control. Number 3, premises. Now this is our first section number, section 1, subsection 3 of the 1957 Act. There is no actual definition as such provided by the statute, but there is reference to premises being sort of any fixed or movable structure. Now there are a number of cases that deal with different types, but it's really beyond the A level that we're dealing with here. So if you look over, revision, most of the time it's going to be obvious. So as I said, building, part of a building. If we go, for example, and talk about said building, it could be if the lawful visitor, the claimant, suffers personal injury or damage when they slip on a step going up the stairs because something's been left there and they trip and fall over it. So in that case the premises would be the stairs. If somebody is, say it's a hotel, for example, and somebody's out on a balcony and the balcony collapses, the premises more specifically should be identified as the balcony of the hotel, and so on and so forth. I think other examples have also been ladders. They're fixed or indeed movable structure, so it could be a ladder. If someone climbs a ladder and they fall off, maybe it's a bookshop or something. I think as well, we've also got ships that are in dry dock, so it's probably unlikely to have that in the exam, but a ship that is out at sea would not be considered fixed, but a ship in dry dock would. But I think most of the time it'll be pretty obvious. Then, more specifically, we get to point 4 for the 1957 Act, which is duty of care. Now, this is under section 2.2, which I always think is easy to remember because it always makes me think of what a ballerina wears, a tutu. And this is to keep all lawful visitors reasonably safe. So, for instance, again, if you invite someone to your property, let's say you're inviting them to your house for a party, then it's not expected that you're going to keep them completely safe. That would be an unreasonable threshold, but reasonably. So sort of going back to that sort of objective test. Again, you're inviting someone like a plumber or electrician. You've contracted with them to come to your property to fix something. You wouldn't leave things out that could potentially pose a danger. And that's really where we're coming from. The question of whether or not the claim is going to succeed is dealt with point 5, and that's breach of duty of care. So, as I say, it's returning to this objective test, very similar to what we've done in a previous video with basic negligence. And the question is asked, does the defendant's, or indeed the occupier's, standard of care fall below what is expected of a reasonable person? Now, all of those risk factors that we covered in a previous video for the topic basic negligence are relevant again here. Indeed, they are relevant for whenever you're talking about breach across any of the tort law sort of topics that we deal with AQA law. So you just might want to look back. I didn't label them out here, but we had, for example, special characteristics of the claimant. If the defendant, the occupier in this case, was aware of any special characteristic, perhaps, for instance, the claimant was disabled, and they offered no sort of care towards them when they were on the property, and they injured themselves. Size of the risk, precautions taken, and sort of so on and so forth. There were some others as well, but those are usually the ones that get referred to the most. Key case here then is Laverton and Kaya Pasha. I will mention this briefly, and you'll know that this is the takeaway shop case where an intoxicated woman wearing these boots with incredibly high heels came into the takeaway shop, and she ended up slipping and injuring herself, her ankle, I believe. Now, she tried to bring a claim to say the takeaway shop had breached their duty of care in keeping her, as a invitee to that shop, or as licensee, keeping her reasonably safe. The claim failed because, of course, when they looked at it, they found that the shop had done everything sort of that was expected of a reasonable person. They had, given that it was raining outside, they mopped the floor whenever they could, but they couldn't obviously continuously mop it because, of course, they had to serve people as well, and the takeaway shop was busy. They had also installed the slip-resistant tiles. So again, that's some expense that they had, taken to try and, if you will, as a precaution to that risk that anyone might slip. And as I mentioned before, the claimant herself was intoxicated, so she contributed certainly to her injury. So there was no claim in Laverton and Kaya Pasha, and I think that case illustrates that quite well. Now, like with any sort of claim really in tort law, you're having to establish damage, which in another way is causation, isn't it? The argument has to be with evidence that the claimant proves that the defendant, in this case the occupier, has, through perhaps their carelessness or whatever it might be, caused the damage, the personal injury or property damage. Now that's factual cause and legal cause. We dealt with this in a previous topic, you'll remember, so this is going again back to basic negligence. You can see how it all fits. And just very briefly, factual causation was is the but-for test, and I believe that's the Barnet and Chelsea and Kensington Hospital case. But for the actions of the occupier in this case, would the claimant have suffered damage? And the claimant wants the answer to be no, and in other words saying, you are responsible. But we also need legal as well. So for legal, we refer to that as the claim, has to be reasonably foreseeable, not too remote. We use the Wagon Mound case for that, I believe. And again, if I go back to my example of you inviting someone around your house and you've left, children's toys up the stairs, and the person, wants to use the toilet and goes upstairs and slips on a toy, then I think it is reasonably foreseeable, isn't it, that you have certainly breached your duty of care to keep your visitor reasonably safe, because they've slipped on a toy and it's resulted in damage. There's a clear connection there. There are also, for instance, the thin skull rule we dealt with. You'll remember the case of Smith and Leach brain. So just have a look over at those things. And most of the time in the questions, I have to say, damage is not going to be a problem. So deal with that quite quickly, if you would. But I think it's probably good practice just to briefly outline the test and just say there are no issues here, sort of thing. Then we move on to defences, which you have to look for. And what makes the 1957 Act a bit more challenging, certainly, is I've listed them here from A to I. You've got various things here. So firstly, we've got the occupier, the defendant, could claim that it was an accident. That, in other words, they were not aware of any sort of danger. And that case of Cole and Davis Gilbert illustrates that quite well. I believe that was the case where the claimant was walking across a village field or green, and there was a hole in the green itself. Now, in the village green, I think they use that for maypole dancing. So they stick a big pole in it, and they sort of, as part of the celebration for summer, dance around it. When that had finished, they would fill the hole in, but some unknown third party had come and dug the hole back up, and then when the claimant walked on it, ended up falling in and breaking their ankle. So there was no fault whatsoever on the occupier. So you could try accident. B, you've got that the parent or guardian should be supervising with Phipps and Rochester. Again, I think this was involving children in this instance, and I think one may have been 7 years old with his sister crossing a field again, and there was a sort of deep trench that had been dug by the defendant for sewage, and the young boy fell into it and injured himself. So again, if there's a situation where children are involved, we'll come back to them again in a minute, if they suffer personal injury or damage and it was clear that they should have been supervised, certainly the younger the child, the more likely that is to succeed as a defence. If I go over to the right hand side quickly, just to say, to link this in, if you do have a problem scenario that deals with the claimant as one of the claimants is a child, then you really need to also make the link that we're dealing with the fact that children are attracted to risk. It's known as allurement. And so what's interesting about this 1957 Occupiers Liability Act is that there is a duty of care on the occupier, an expectation that they should be prepared for children, basically, to be attracted to risk compared to adults. So the case of Glasgow, Corp and Taylor sort of illustrates that, I suppose. This is section 2, subsection 3 of this 1957 Act. And I think here we've got the occupiers were the owners of botanic gardens. and they had various, plants and shrubs grown there. And a young child who actually went into the garden because it was open for the public picked some berries off of one of the shrubs and ate them, and in fact these berries were poisonous, and sadly the child died. So whereas an adult hopefully would know you shouldn't be picking strange fruit off of a shrub and consuming it, a young child would not, and they're attracted to that risk and would like probably to know, what's it taste like, and so on. So in that instance the occupier is held to be at fault and liable. But going back to what we just said, if there was no parent or guardian around, they could potentially, the occupier, use that defence found under Part B. And these would be complete defences, accident and parent guardian. Also a complete defence is found under Part C if the occupier is given an effective warning. So again, found under Section 2, subsection 4. And then we've got the case of Ray and Mars. I'm not sure if in that case the occupier was successful with the defence. I think in that instance it was a building that was in darkness inside, and you had no artificial lighting, and there was a deep pit inside, well, basically more or less as soon as you entered the building, and therefore having a warning sign inside the building wouldn't be any good to anyone. In fact, it wasn't to the claimant who fell in and was injured. So we just use that case to highlight that if it is an effective warning sign, which can be verbal or indeed written, then that might be again a complete defence. Obvious danger, again, this is a complete defence found in Cotton and Derbyshire case. Well, here, for instance, you had the claimant who, well, I say claimant, sorry, it was a group of friends, and one of the friends, they were intoxicated, ended up going off the beaten path and falling off a cliff and suffering serious injury. I think, in fact, they may have even have died. So the person who brought the claim, family, I presume, this defence succeeded because as they went off the path, and a cliff is obvious danger, really, again, the occupier can't be held at fault. The next two are familiar to you from the topic of basic negligence. So we've dealt with contributory negligence before, which is basically the argument that the occupier could say, yes, I was at fault, but at the same time the claimant is at fault too. And what this can mean is the judge will take that into account when awarding damages, in other words compensation, and it could potentially be reduced by as much as 100% of the damages, although that's only in sort of rare cases. So that's really about sharing the blame, Part E. It's not a complete defence, but it can limit damages that the occupier may have to pay. Consent, noting this is not for road traffic accidents or anything like that. Again, I think fixed premises can involve vehicles as well, but consent would be off the table for that. That's found under Section 2, subsection 5. I believe there was a 3-part test, which you'll need to look at again. We covered it in basic negligence. Again, off the top of my head, I think it was something like you've got to prove, if you're the occupier, that they were aware of the risk, had precise knowledge of the risk, and there was voluntary acceptance of that risk, and all 3 parts have to pass. I think, again, talking of the exam, if you struggle to remember the 3-part test for consent, then just, identifying that consent could be a defence and sort of explaining as best you can as to why you think it is will gain you marks. But students that want to do sort of, gain more marks in the exam would be expected to cover the 3 parts and apply them. Exclusion clause, Section 2, subsection 1. Really, exclusion clauses we generally deal with, don't we, in contract law, in AQA law, but might there be a situation where an occupier or a business or some such is trying to completely limit their liability for, say, personal injury or indeed, property damage? And again, that could be a complete defence if the claimant is aware of it before they suffered the injury or property damage. H, negligent third party found under section 2 subsection 4b, is again a three-part test. This is where essentially the occupier is blaming it on a third party. Look for this in problem scenarios where the occupier has had someone do some work for them, perhaps. Could be a tradesperson. And ultimately that work isn't good enough. So the test here is it reasonable to give work to the specialist? So say, for example, let's say some decking needs to be put out, needs to be erected in somebody's garden. I wouldn't know, how to even begin to do that. So that's why you would hire a carpenter or a builder. So it would be reasonable to give that work to a specialist. Now, are they competent? This is where you would look for things like, do they have insurance? Do they have the requisite qualifications? And in reality, we'd probably look at something like a website or check a trader, and we'd see if they're meeting all these requirements. So insurance and qualifications and experience is where competency comes in. You wouldn't just blindly give the job to somebody that you met down the pub, for example. And then lastly, that the work was checked. Now, this is expected of the occupier. If I go back to my example of decking in a garden, once it's done, it may look lovely, but has the person, visually inspected it? Have they actually tried standing on it to see if it would, take the weight of a person? Because if, for instance, they didn't stand on it, and then, I don't know, they invited friends round for a sort of evening meal or something, and they go out into the garden, and the first moment that they step out onto it, it gives way, then they, the friend could bring a claim against them for the injury they might suffer. The occupier then would want to say, well, it's not my fault, it was down to the carpenter or builder that did the decking. However, they have to prove all three parts, so if they haven't checked it themselves, that defence, I'm afraid, would fail. But if they did check it and it seemed all right, then that defence is a complete one. The more specialist or complicated the work, I suppose it's expected that you may even have a situation where the occupier may need to get another specialist or someone with knowledge to check it. Maybe if work that was done was to do with electrical installations, for example. So again, I wouldn't know where to begin there or to check it. So it's quite a sort of high threshold, that test. And then with I, we've got the tradesperson should guard against associated risk, section 2 subsection 3b. In this case is Rolls and Nathan. It's very important we link that to associated risk with the job. So thinking back to exam questions we've seen previously, if somebody was an electrician, for instance, that was contracted by the occupier to come to the property to sort out some loose wiring, and this loose wiring is sort of around the perimeter of the room, the skirting on the floor, and there's a loose nail or a nail sticking out, if you will, and the person who's dealing with the wiring catches their thumb or cuts their hand or something. You could then, as an occupier, if you faced a claim from that electrician, you could raise this defence and say, well, look, you're a tradesperson, you should be aware that when you're dealing with wiring, and certainly when you're dealing with wiring, in a property, that there could be dangers such as a nail that's hanging out that could cause an injury or whatever. I think another problem scenario we saw is somebody who was, I'm trying to remember now what it was. I think they there was something where they had to inspect something on the roof of a property, and yet they, decided to try and climb to the roof themselves without sort of doing what they properly should. And so again, you could say if they're taking risks that otherwise they shouldn't be, then again this defence will be a complete one and work. And then finally we end with remedy, and remedy, as usual, would be damages. So we're looking to compensate the person who suffered the personal injury or indeed property damage, try and put them back into the position they would have been before this occurred. That's harder to do, isn't it, for personal injury? But that's when, if you look at it a bit deeper, we may do this in another video. You'll remember we talked about things like general damages, special damages, claiming for medical expenses, loss of amenity, change in lifestyle, loss of a salary if you can't work, and all these kind of things. But again, if you struggle with that at the moment, just identifying damages, compensation, and maybe name dropping one or two things would certainly be better than nothing. Right, so that's the 1957. It's quite long, wasn't it? What I've done here on the next slide is I've created an exam question, so one that as my students have never seen before. I put it as 10 marks, but truth be told, it would probably really be one person, one paragraph, but I wanted to get a couple of points in there. So I'm stretching it a little bit. So here we are. Moira hires a builder, Kevin, to put in a concrete base and erect a large shed for her husband, Danny, in their garden. Arranging a date for this, Kevin arrives one morning and is welcomed by Moira. She shows him the garden and explains the shed is a birthday gift, as her husband likes to spend lots of time there at weekends. Later, as Kevin is finishing erecting the shed, he takes a few steps back to view his work and trips over a nearby garden gnome, badly spraining his ankle. An ambulance is called as a precaution and Kevin is taken to hospital. Later in the day, Moira's neighbour Jenny comes round to see Moira and the work done. Moira says to Jenny to open the shed door and have a look inside. However, when she closes the shed door, she discovers she can't open it again. Or she cannot open it again. Jenny tries to force the door and the whole shed comes down on top of her, resulting in a serious head injury and a broken arm and leg. So the question here is, with regard to the law on the 1957 Act, advise Kevin, the builder, and Jenny, the neighbour, of their rights and remedies. So just very briefly, as we run through, what would I be expecting? Well, remember, use the checklist that we just looked at previously. Because this is a 10-mark question, it tells us it's the 1957 Act. Whereas if it's a 30-mark question, be a longer, I know, you would have to make the distinction between whether it is the 1957 Act we're dealing with as a claim or the 84 Act. Now, Kevin's a builder, and Moira has contracted with him to come round and do some work in the garden, namely to erect the shed. So in that sense, we say Kevin is a lawful visitor. And we can say the same for Moira, can't we? Because coming round to see Moira, presumably then Moira has invited Jenny round, or certainly allowed her to come into the garden. Then we deal with the next bit in our checklist, which was occupier, which is anyone in control of the premises. Now, very quickly, we can just say that Moira is in control of the premises. The premises in this case would be her garden, or more specifically, actually, the shed. So the premises in this question would be the garden shed. Let me just fact check that for a sec. So actually, for Kevin, he trips on the name. I guess for Kevin, it's the it's the garden itself, or the gnome, and then for Moira, it's the shed. And then we go into the duty of care. Remember, that's section 2.2, and that is that Moira is expected to keep all visitors reasonably safe. Has she breached that duty of care? Has her standard of care fallen below what's expected of a reasonable person or occupier? And I think firstly, if we look here at Kevin, I don't. She doesn't. I, has she breached it? You could argue potentially maybe there are a number of garden gnomes lying about. There are things that are hazards in terms of risk of tripping or falling in the first instance, and then in respect to Jenny in the other, you could make an argument that Moira herself has not actually looked at the garden shed, gone inside of it herself, and given that there were some problems earlier with the builder having to be taken away by ambulance, had he actually properly finished the shed, if you see what I mean. Risk factors that are relevant, have a look at those. You might think of things like size of risk, precautions taken. I mean, for example, in the first one, just off the top of my head, could Moira have moved any garden ornaments, such as gnomes, out of the vicinity so that they didn't provide a hazard for tripping? And then in respect of Jenny, who went inside the shed, again, has she properly inspected the shed, gone inside and otherwise? Because it sounds to me like the job's half done. And then we would look at damage. I think in both instances that wouldn't be difficult to prove. You then have to look at defences. So what do you think may or may not be relevant here? I think if you look at the first paragraph with respect to the builder, you might want to make an argument of tradesperson guarding against risks associated with their job, because I think that if you are somebody that's erecting sheds in a garden, a garden gnome or garden ornaments aren't necessarily going to be out of place and should be something that Kevin should be aware of. So I would potentially argue that. You could even argue, if you're more maybe accident, maybe it's just a pure accident and no one's at fault. If either of those fail, then maybe you'd want to try contributory negligence potentially. You could say that perhaps at the very least Kevin is at fault for not minding where he's going, and so if Moira is to lose her claim, in other words Kevin's to win his claim, the damages could be reduced, which is at least some good news for Moira. If we're looking at Jenny's part, I think that the key defence that's calling out to us is the third-party independent contractor defence that Moira might like to use. In other words, she's going to say, it wasn't me, it was the third party, namely Kevin, right, who erected this shed and did so negligently. So again, look back at our checklist. What were the 3 points? And I think we said, didn't we, that was the work, was a specialist required for the work? Well, I think yes, because I don't think there's any indication that Moira, like many people, would know where to begin with, doing a concrete base, erecting a shed and so forth. Is Kevin, the builder, actually competent? Well, this scenario doesn't really give us too much, but we can talk about, well, did she check he had insurance? Did she check that he had the requisite experience and qualifications? So there's a bit of scope for that. And then I think that lastly, remember the 3 parts, is did Moira herself check the work? And I think, judging by this scenario, she has not checked the shed herself. She's not gone inside it. So I think that whilst you would talk about that defence, it would ultimately more than likely fail. Any other defences, I think, can you see for that last bit again with Jenny? Jenny tries to force the door. I don't think you could really argue consent, because I don't think she would know or have knowledge of the precise risk. Could you argue contributory negligence? No, I don't think so. So I think ultimately that's where we finish with that one. And again, the remedies part of the question, we can say damages presumably for Kevin in relation to his personal injury, and he's going to need his medical bills paid for. He's not going to be able to work for a little while. So again, he could make a claim for that. Is there loss of amenity or lifestyle there? For example, I don't know. Is he a keep fit fanatic or like to play football at the weekend? We won't be for a while. He's going to find it hard to get around. So these are all things that damages could take into account, and he'd have to mitigate, that injury, mitigate his loss. So he has a duty not to make that ankle injury any worse. So that's something to take into account. And then finally, with Jenny at the bottom, same thing. I think even worse, actually. She's got a serious head injury, broken arm and leg. Is she working? Again, she won't be, will she? So damages could take into account a salary. There are going to be medical bills as well. Again, loss of amenity. So a great number of things there. And that looks quite serious. But please have a go at answering this question as part of your independent study. And then if you're my students, you can submit that to me on Google Classroom. I'm now going to move on to the 1984 Act, which is a lot quicker because we've covered a lot of these things already. So the key thing for the 1984 Act is that we're no longer dealing with a lawful visitor, we're dealing with an unlawful one, which in other words means a trespasser, someone who does not have permission to be there. Points 2 and 3 are essentially the same as before. So for number 2, there needs to be an occupier in control of those premises, so we can use the same case. Premises, well, here's the thing, there is no mention of premises in the 1984 Act in terms of a definition. The only mention that we had goes back to that 1957 Act of it being any fixed or movable structure. So once again, you can quote that or use that, and you're looking for the same things. Is it a house or a building? Is it part of the house or a building? And so on and so forth. The difference, though, for the 1984 Act is found in the duty of care. We're now dealing with Section 1, subsection 3 and 4. There are 3 parts to this, so can be quite challenging to remember. So here we're basically saying, is the occupier aware of the danger or have reasonable grounds to believe that danger exists? That they know or have reasonable grounds that the claimant may come in vicinity of the danger, so that's our trespasser, and was the risk as such that reasonable protection is expected. So this, to try and break this down, is the occupier aware of the danger? Do they believe that the trespasser, the unlawful visitor, will be in the vicinity of it, and is reasonable protection expected? Number 5, same as before, breach of the duty of care. We measure them again to the objective test. Those risk factors and so on and so forth are there. I've got damage there. Actually, damage, I notice, should be 0.6. I think I've combined it with 0.5, but it's still on the sheet. Just a quick thing about children in terms of this claim. Once again, if your problem scenario deals with a child, children are attracted to risk, as we said before, but interestingly, while one of the changes is that an occupier will owe a duty of care to a child trespasser, it's not quite the same standard as the 1957 Act. So whereas in the 57 Act, there had to be an appreciation that children may not perceive risks that adults do, for the 1984, because they've trespassed and there's a degree of fault there themselves, it's simply a case of to the same standard as an adult. The British Railway Board and Harrington case is the case we want to use, and here, if I remember correctly, is where we had a situation of there was a hole in a fence in the occupier's land that bordered on a railway that was adjacent. And I think in this instance, the occupier was aware that children were using that hole in the fence and the railway as a shortcut. They did nothing about it, and ultimately one child ended up getting electrocuted and suffering personal injury on the railway line. So the law certainly wanted, on a moral argument, on a moral sense, to ensure that where you're the occupier, and again, you're aware of a danger, or there are reasonable grounds that danger exists, that you should do something. Then we've got defences, and here I've listed them A to F. Some of them are similar but with different cases now. So again, obvious danger, we've got Ratcliffe and McConnell. And then we've got time of day, Donahue, Folkestone Properties. C, no reason to suspect a trespasser, Higgs and Foster. Consent is found under section 1, subsection 6. Contributory negligence is there. And once again, an effective warning sign, be it verbal or written, is under section 1, subsection 5, the Westwood and Post Office case. I'm trying to remember the facts of Ratcliffe and McConnell. I think in that instance you had parties who broke into a swimming pool. I think it was a swimming pool at a school or some such thing, and they were diving off of it, in the shallow end, and one of them suffered personal injury. So I think that was the obvious danger, but do check that. The no reason to suspect a trespasser, Higgs and Foster. I think there was a police officer surveilling a suspect, went onto the property, ended up falling into a sort of a pit in a garage. So again, the occupier had no idea that a policeman was going to go onto that property, and so on. I don't have much facts at all on Westwood and Post Office that I could find. But again, don't worry too much about the facts. It's about making sure you've got the right defence, linking it in the problem scenario, and then putting it to the correct section number in case. And the remedy again would be damages, compensation, but I'll add this to the sheet afterwards. Under the 1984 Act, there is no claim for property damage, only personal injury. So the question that I've done here, finally again for 10 marks, Charlie is a property developer, purchases a building near a secondary school. He is told by a neighbour that children from the secondary school like to play in the grounds. However, he's unaware that some are using a fire escape attached to the building as a climbing frame. Johnny, 11, is with some of his school friends and watches one of them climb the fire escape to see how high they can go before climbing back down and jumping off. Daring Johnny to try and beat him, Johnny climbs the fire escape but loses his grip and falls about 30 feet, sustaining a head injury. It is later medically assessed that Johnny has sustained permanent brain damage. So with regard to the 1984 Act, advise Johnny of his rights and remedies against Charlie, the property developer. So again, looking at the handout as a checklist, we are dealing with an unlawful visitor because, of course, Johnny, 11, is a trespasser. He has no permission to be on the grounds. Then we deal with occupier. Well, that's got to be Charlie, who is in control of the premises. The premises here would in fact be, more specifically, the fire escape. Then we go to duty of care. I believe we said that was under section 1, subsection 3 and subsection 4. Comes in 3 parts. Is Charlie aware or have reasonable grounds that a danger exists? Now this one is certainly questionable, but I think children should not be messing on a fire escape, given the danger that they could potentially fall. But it does say, doesn't it here, he's unaware that some are using a fire escape. So there's a bit of room there to argue, should he really ultimately be at fault for breaching his duty of care? Did he know that, or have reasonable grounds to believe that children would be in the vicinity of said danger? Again, that's questionable. And then lastly, is the risk one that reasonable protection is provided? I mean, he hasn't done anything, has he, Charlie? So we could certainly say there's a degree of fault there, but ultimately it's for you to decide whether he's breached. If we go to damage, I think that factually and legally we can establish that, no problem. We can talk about, allurement, because Johnny is a child, 11 years of age. That's our Glasgow Corp and Taylor case. So in this instance, he would be held, he does have a duty of care, but it's no different to what he would owe an adult. So the fact that Johnny, or indeed children, are attracted more to the risk of using the fire escape, I would say in this instance, you could argue is neither here nor there, really. Then you've got the fact of there any defences. Now, could you argue obvious danger? Potentially so. Could you argue, well, I mean, there's no effective warning sign, written or verbal, that's been given, and that really probably would have helped. You could certainly argue contributory negligence, couldn't you? Johnny is really at fault as well. So if Johnny did win his case as a claimant, damages could be reduced. Could you argue consent? Again, I don't know. 11 years of age, how much would one know about the precise risk? You could argue it, I suppose, as well. So these are just some of the things that are coming from this. And then we go to, finally, remedy, which again would be damages, compensation. It looks like, given the severity of the injury, we're talking about medical bills, we're talking about loss of lifestyle and amenity again, aren't we, and so on. This potentially affecting his future and what he can achieve in education and go on to, if it's even possible, have a career. How badly affected has he been? So all of these things can be taken into account for damages. There wasn't any property damage that we can see here, so we don't have to say anything about that. But again, if you want to have a go answering this, then please do, and it will be, I think, a really good idea for your independent study and revision. And that's the topic done. Longer video, I know, but I'm going to pause it there. Good luck with your revision.